Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. I must say I have been very anxiously waiting to see the actual state's motions in limine ever since we learned that they were filed on Friday the 21st. And guess what? They are now on the docket. Let's start with the state's motion in limine regarding the alibi defense. They are available for you to review if you follow the link that I have provided in the description to this podcast episode. Scroll down to Idaho cases of judicial interest where the Kohoberger case is, and you will now see this document published on the 21st of February 2025. And I must say, I believe that the state has a good argument here. They're saying here comes now the state of Idaho by and through the Latah County prosecuting attorney. William Thompson is who signed this, and respectfully moves the court in limine. This is a motion in limine. A motion is an application for a court order. They're asking for this prior to the jury trial this summer, prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. I agree wholeheartedly with this statement. If you have not yet had the opportunity to listen to and to review my prior presentations, including whatever happened to the alibi defense that is published on the YouTube channel, please do so, because it goes over what the requirements are in Idaho when one produces an alibi defense. Mr. Kohberger, in no way, shape, or form is required to put up any defense. He is cloaked with the presumption of innocence. The Fifth Amendment to the United States Constitution guarantees he can never be compelled to give evidence against himself. However, if he raises an alibi, as he has done here, stating he was nowhere near 1122 King Road at the time of the horrendous atrocities that occurred the morning of November 13th, 2022, there are certain things he needs to do. He needs to produce evidence of who could confirm firsthand that he were somewhere else. For example, if he were in a hospital recovering from surgery, then a doctor, a nurse, a medical administrator from whatever hospital could then be called on to say, yes, I know for a fact that Mr. Kohoberger was nowhere near 1122 King Road because he was at the hospital, inpatient, for multiple days over the time that this crime happened. Or someone perhaps who was on a plane with him going overseas who could say, yes, I sat next to him. We talked all the way across the ocean until our plane landed in Athens. That's what's required for an alibi defense. If the defendant is not going to get up on the stand and testify on his own behalf. What he's trying to do here in the partial response to the alibi, as we covered in whatever happened to the alibi defense, is try and get testimony in from someone who doesn't have direct knowledge, an alleged and we don't know if he's disclosed yet as an expert trial witness, Cy Ray, who might be able to testify via some expertise that Mr. Ray holds, but that's not what the alibi defense requires. The state here is referring back to their prior initiatives dating back to May 2023 regarding the request for discovery, disclosure, alibi demand, and what happened thereafter. I definitely recommend that you read this, but I think they have an excellent argument here that the only way that this alibi defense can be introduced at trial would require Mr. Kohoberger to get up on the stand and testify in his own behalf. This is Kathy. Thank you for joining us here today.